to the law that applies in this case. You will then retire to decide a verdict or verdicts in this case. In order to reach fair and just verdicts, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes that the defendant is charged with. You have to understand how convinced one way or the other you should be before you reach a verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you, regardless of any opinion you may have as to what the law ought to be. The law, as I explain it to you, is the law that you must follow in reaching a verdict. It is up to you to decide the facts in this case. You've heard that before. You must decide the facts solely from the evidence at trial. You must apply the law given in these instructions to the facts, and in this way reach a fair and just verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented to you and the law as I explain it to you. The fact that the defendant has been charged is not evidence of guilt. The charging documents, called indictments, are simply a way of giving the defendant notice of the charges against him. It is a formal way of accusing the defendant of a crime in order to bring the defendant to a trial. You must not consider the indictments as evidence of guilt of the defendant. Likewise, the possible punishment of a defendant if you return a verdict of guilty should not influence your decision. The duty of imposing sentence is for me, the judge. You should consider the evidence presented and base your verdicts only on the evidence without considering the issue of punishment. A person accused of a crime has an absolute right not to take the witness stand to testify. The fact that Mr. Holloway, the defendant in this case, did not testify may not be considered by you in any way in deciding this case. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. As I've told you before, the defendant has no obligation to present any witness or prove his innocence. You have heard the lawyers discuss the facts in the law, as well as Mr. Holloway, in their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers or Mr. Holloway have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers or Mr. Holloway. If the lawyers or Mr. Holloway have stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Before this trial began, I was asked to give permission for cameras to be used during the trial. Obviously, I gave that permission so that during the trial, cameras were permitted to be here in the courtroom and also on the view. The fact that there were cameras present during this particular trial does not make this trial more important than any other trial. All criminal trials are equally important to the defendant and the community. You should not draw any inference or any conclusions from the fact that during this particular trial, cameras were present. Now that you will be beginning your deliberations, your complete attention should be focused on the trial. You should ignore the presence of the cameras in the courtroom and at the view as you deliberate in this case. It's not for your consideration. During your deliberations, you should consider only the evidence in the case. The evidence consists of the testimony of a witness under oath during both direct and cross-examinations and any other examinations I allowed, any exhibits which have been admitted into evidence, and the view. During the trial, the lawyers, as well as Mr. Holloway, made objections. The lawyers and Mr. Holloway are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or the evidence would have been. If you believe that I have expressed or suggested an opinion as to the facts in my rulings, you should ignore such an opinion. It is up to you alone to decide the facts in this case. In short, you should consider only the legally admissible evidence in deciding this case. That is the testimony of the witnesses, the exhibits, and the view. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based on personal knowledge. That is what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence, on the other hand, is indirect evidence which tends to prove a disputed fact by proof of other facts. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that this courtroom had windows to the outside and that looking out you could see that it was raining. That would be direct evidence that it was in fact raining. Now assume that the courtroom has no windows, but that as you're sitting here, someone walks in wearing a raincoat and carrying an umbrella, both of which are dripping wet. Now since you cannot see outside, you have no direct evidence that it was raining. But on the facts I have asked you to assume, it would be reasonable and logical for you to conclude that it was raining outside. That is all there is to circumstantial evidence. You infer on the basis of reason and common sense from an established fact the existence or the non-existence of some other fact. You should consider both types of evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more of the elements of the charged offense, then in order to convict, you must find that the totality of evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. Therefore, if there is a conflict between witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there were two eyewitnesses to a crime, and one witness testifies that the defendant committed the crime, and the other witness testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must resolve the conflict and decide whether, based on all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. In summary, you should consider all of the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. Let's talk about how you determine the credibility of witnesses. You as jurors are the sole judges of the credibility of a witness in the weight their testimony deserves. That is, it is up to you to decide who and what to believe. If there is any conflict between what a witness says and other evidence, then you must decide where the truth lies. Simply because a witness has taken an oath to tell you the truth does not mean that you have to accept his or her testimony as true. You should carefully scrutinize all the testimony given on both direct and cross-examination and any other examinations I allowed, the circumstances under which the witness has testified, in every matter in evidence which tends to show whether a witness is worthy of belief. Consider a witness's intelligence, motive, state of mind, and demeanor on the witness stand. Consider the witness's opportunity and ability to observe matters as to which he or she has testified, and whether the witness impresses you as having an accurate recollection of these matters. Consider also any relation a witness may bear to any party or side of the case, the manner in which the witness might be affected by your verdict, and the extent to which, if any, a witness is either supported or contradicted by the evidence in the case. You should consider all of these factors in evaluating the credibility of any witness, including a law enforcement officer. After making your own evaluation of credibility, you should give the testimony of a witness such credibility as you think it deserves. You may accept all of what a witness has said. You may reject all of what a witness has said, or you can accept some and reject some of what a witness has said. In determining the credibility to be given to the testimony of a witness, you should use your common sense, your good judgment, and your life experience. Let me talk about prior inconsistent statements to you and how you're to consider those. In deciding whether you believe a witness, you may consider whether the witness made statements before trial which were not consistent with what the witness said at trial. If a witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe that witness's trial testimony. You may not use the statement made before trial as proof that the facts in that statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. Any statement made by the defendant before trial can be considered for its truth. Any statement made by a witness under oath during the trial, which was not consistent with subsequent testimony of the witness at trial, may be used to decide the credibility of the witness as well as for its truth. You heard the testimony of an expert witness, Jill Theriault, in this case. An expert is someone who has specialized knowledge, such as scientific or technical knowledge, that qualifies the expert to give an opinion as to matters that are not common knowledge. The opinion of an expert may assist you in understanding the evidence or deciding the facts of this case. You are not bound by the opinion of an expert. You are free to ignore the expert's opinion if you find that the reasons given in support of the opinion are not sound, or if you find that other evidence outweighs the opinion. Now I want to review the intoxication consideration with you. Evidence has been presented that the defendant was intoxicated at the time of the crimes. Being intoxicated is not, as such, a defense. However, you may consider evidence of intoxication in deciding whether the state has proven that the defendant acted purposely for the attempted murder charges, knowingly for first-degree assault, possession of a firearm, and simple assault, or recklessly for the second-degree assault. If, considering all of the evidence, including evidence of intoxication, you decide that the state has not proven beyond a reasonable doubt that the defendant acted purposely for the attempted murder charges, knowingly for the first-degree assault, possession of a firearm, and simple assault charges, or recklessly for the second-degree assault charge, then you must find the defendant not guilty. On the other hand, if considering all the evidence, including the evidence of intoxication, you decide that the state has proven each part of the definition of attempted murder, first-degree assault, possession of a firearm, second-degree assault, and simple assault, including that he acted purposely, knowingly, or recklessly, whichever mental state applies, then you may find the defendant guilty. In reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or quantity of the evidence that is important, but the quality of the evidence that is important. Now let's go over the constitutional provisions surrounding the burden of proof. Under our Constitution, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you, beyond a reasonable doubt, that he is guilty of every element of the alleged offense. If, after all of the evidence and the arguments, you have a reasonable doubt as to the defendant committing any one or more of the elements of the offense charged, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable simply means that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or a fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offense beyond a reasonable doubt, you should find the defendant guilty. All right, let's just take a little break. If you need to stand up and stretch to keep your attention riveted, have at it. If you need a little water or just to stretch, just do that. Just be a short break for both myself and you. Otherwise, continue to give me your full attention. Everybody's all set with water? Great. Good, we're about halfway there, folks, so we'll keep plugging away. Very good. Everybody's seated, ready to go again. Now I want to explain to you what a criminal offense is in New Hampshire. The laws of New Hampshire set forth certain crimes. Each crime has a definition. The definition of each crime requires the state to prove that the defendant committed a certain act or acts and that the defendant acted with criminal intent. A crime is the breaking of a law for which the law provides punishment. All crimes have at least two parts. First, an act, and second, an intent. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his intentions were. The word intent refers to what a person mentally believes his physical acts will accomplish, and the word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. Number one, he must have mentally intended to do something criminal. And number two, he must have physically acted to do something that is criminal. Unless a person both intended and acted to do something criminal, that person has not committed a crime. This means that if a person either did not mentally intend to do something criminal, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember, the reason crimes are given different names is that each refers to a different intent, or a different act, or a different act and a different intent. Sometimes the only reason identical acts are given different names is that they refer to different intentions. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other driver did so out of carelessness, they would not be guilty of the same crime. Thus, you can see how the act and the intent can make a difference. In this case, the state has alleged that the defendant committed 7 crimes as described below in these instructions. Each of the charges against the defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on one charge should not influence your verdict with respect to the other charges. In other words, you should evaluate each charge individually. Let's go through the 7 charged offenses. all the elements of each offense, and all of the applicable definitions. The defendant has been charged with 2 counts of attempted murder as follows. Charge ID number 171343C alleges as follows. In that with the purpose that the crime of murder be committed, he purposely attempted to cause the death of CM by shooting her with a firearm, a deadly weapon as then and there used, which under the circumstances as he believed them to be, constituted a substantial step toward the commission of the crime of murder. Charge ID number 1678542C charges, in that with the purpose that the crime of murder be committed, he purposely attempted to cause the death of SC by shooting him with a firearm, a deadly weapon as then and there used, which under the circumstances as he believed them to be, constituted a substantial step toward the commission of the crime of murder. The definition of the charge of attempted murder has 3 elements or parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove, number 1, the defendant attempted to cause the death of another, and, number 2, the defendant's actions constituted a substantial step toward the commission of the crime under the circumstances as he believed them to be at the time, and number 3, the defendant acted purposely. Certain words in this definition need further defining. Deadly weapon means any firearm, knife, or other substance or thing which, in the manner used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. As part of that definition, serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss or impairment to the health or function of any body part. Substantial step means acts which strongly support the conclusion that the defendant intended to commit the crime of murder. It is up to you to decide whether the defendant's acts constitute a substantial step toward the commission of the crime. Purposely, which is the intent or mental state as we call it. A person acts purposely when his conscious object is to cause a certain result or engage in certain conduct. The state must prove that the defendant had the conscious object to cause the result or engage in this conduct. The key words here are conscious object. To have a conscious object means to have a specific intent. It means that the defendant desired to cause a certain result or engage in certain conduct. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to do a particular act, in this case, cause the death of another. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all of the facts and circumstances and evidence in deciding whether or not the state has proven that the defendant acted purposely. Additionally, the defendant has been charged with 2 counts of first-degree assault as follows. Charge ID number 1713433C charges in that Dale Holloway knowingly caused bodily injury to CM by shooting her with a firearm, a deadly weapon as then and there used. Charge ID number 1678543C charges in that Dale Holloway knowingly caused bodily injury to SC by shooting him with a firearm, a deadly weapon as there and then used. The definition of this crime has 3 elements or parts. The state must prove each part of this definition beyond a reasonable doubt. Thus, the state must prove that, number 1, the defendant acted knowingly, and number 2, the defendant caused bodily injury to another person, and number 3, the defendant did so by use of a deadly weapon. Certain words in this definition need further defining. Knowingly, again, this is the intent or mental state. Part of the definition of the crime of first-degree assault is that the defendant acted knowingly. This means that the state must prove that the defendant was aware that his acts would cause the prohibited result. The state does not have to prove that the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware of or knew that his conduct would cause the result. Again, whether the defendant acted knowingly is a question of fact for all of you to decide. Keep in mind that there is no direct evidence, or there is often no direct evidence of intent, because there's no way of examining a person's mind. You should consider all of the facts and circumstances and evidence in deciding whether or not the state has proven that the defendant acted knowingly. Bodily injury means any harm to the body of another person. Deadly weapon, as well as serious bodily injury, as part of that deadly weapon definition. These definitions have already been provided to you in the prior instruction. Further, the defendant has been charged with the crime of second-degree assault as follows. This is charge ID number 1678545C. It alleges in that he recklessly caused bodily injury to another by means of a deadly weapon when he shot CM in the arm with a firearm, a deadly weapon as then and there used. The definition of the crime of second-degree assault also has three parts or elements. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove that the defendant caused bodily injury to another person, and the bodily injury was caused by means of a deadly weapon, and the defendant acted recklessly. These are the elements of the crime of second-degree assault. Certain words in this definition also need to be defined for you. Bodily and deadly weapon have already been defined for you, so I won't repeat that. Recklessly, again, this is the intent. A person acts recklessly when he is aware of and consciously disregards a substantial and unjustifiable risk that his conduct would cause a certain result. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from the conduct that a law-abiding citizen would observe in the situation. To prove the defendant acted recklessly, the state must prove first that the defendant was aware of a substantial and unjustifiable risk. This means that there must be proof that the defendant knew that there was a substantial risk that his conduct would cause a particular result. Second, if the defendant was aware of the risk, there must be proof that the defendant consciously disregarded the risk. In other words, the defendant decided to disregard the risk and took a chance in doing certain acts that a particular result would occur. Third, excuse me, you must examine the circumstances known to the defendant. From what he knew of the circumstances, you must decide whether his disregard of the risk was a gross deviation from what a law-abiding person would have done. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find that the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from the actions of a law-abiding citizen under the circumstance. It is not enough for the state to prove that the defendant acted negligently. That is, it's not enough to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. Whether the defendant acted recklessly, again, is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence in deciding whether or not the state has proven that the defendant acted recklessly. Additionally, the defendant has been charged with the crime of possession of a firearm as follows. Charge ID number 1678544C alleges in that he knowingly had in his possession a firearm, specifically a .380 caliber pistol. The definition of this crime has two elements, or parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove that, number one, the defendant had in his possession or under his control a firearm, and number two, the defendant acted knowingly. Certain words in this definition need further defining. Knowingly, this definition has already been provided to you. Last charge, the defendant is charged with the crime of simple assault as follows. Charge ID number 167854-6C. It alleges in that he knowingly caused unprivileged physical contact to MC by striking him in the head with an object. The definition of the crime of simple assault has two elements or parts. The state must prove each part beyond a reasonable doubt. Thus, the state must prove, number one, the defendant caused unprivileged physical contact to MC, and number two, the defendant acted knowingly. These are the elements of the crime of simple assault. Certain words in this definition need to be further defined for all of you. Unprivileged physical contact means any physical contact which is not justified by the law or consent. Knowingly, you've already received that definition. Now I'm going to talk to you about your duty to deliberate and give you your final instructions. So we're on page 18 now, people. We're almost there. These are very important principles, as has every other instruction been given, but this guides you in what you're about to do. The principles of law given to you in these instructions are intended to guide you in reaching a fair and just verdict in this case, which is important to both the state and Mr. Holloway. You should decide the facts of this case without passion, without sympathy, and without prejudice, but with honesty and understanding. You should be conscientious of a just result, as that is your duty, your highest duty as officers of this court. Now that all the evidence is in and the arguments are completed, you will be free to talk about the case in the jury room. In fact, it is now your duty to talk with each other about the evidence and to make every reasonable effort you can to reach unanimous agreement. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Try your best to work out your differences. Do not hesitate to change your mind if you are convinced that the other jurors are right and that your original position was wrong. But do not ever change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. No one will be allowed to hear your discussions in the jury room, and no record will be made of what you say. You should all feel free to speak your minds. Listen carefully to what your other jurors have to say, and then decide for yourself if the state has proven the defendant guilty beyond a reasonable doubt based on the law as given to you. Should any member of the jury panel leave the deliberation room for any purpose, you should stop your deliberations. You should only deliberate when all deliberating jurors are present to hear and participate in the discussion. A verdict form has been prepared for your convenience. You will take this form with you to the jury room, and you will have with you all the exhibits which have been properly received in evidence. The verdict form contains spaces for you to check off whether you find the defendant guilty or not guilty. So you will see the 7 charges all listed out by number, and you will be asked what your verdict is individually on each one of those indictments, and you just check off either guilty or not guilty. Once you have finished your deliberations, your foreperson completes the verdict form, signs it where indicated, and then notifies the court officer, who will give the form to me. After I review it, you will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court. I do suggest that the first issue you address when you reach the deliberation room is to select your foreperson, and I'm going to leave it up to you how you do that. The duty of the foreperson of the jury is to act very much like the chairperson of a committee. making sure that each and every member of the jury is given a full and fair opportunity to present his or her views and opinions on each of the issues presented to you for determination. You are each instructed to consider each other's views and opinions, and in the final instance, reach your own conclusions. In the event you have some question relative to my instructions or the legal issues presented in this case, please put the question in writing, have the foreperson sign the question, and write down the time you presented the question to the court officer. He or she will then present the question to me for response, which I will furnish you after I've had the opportunity to discuss the question and the proposed answer with the lawyers and Mr. Holloway. I cannot comment on the evidence as that is not my role. As I said previously, it is up to you to evaluate the evidence and you must use your own recollection of it.